session. God save the state of Texas and this honorable court.
Thank you. Please be seated. Welcome, everyone. Just due to some logistical difficulties, we're going to start with the second case first, Texas Department of Insurance versus Sam Thomas. Both sides present and ready.
Yes, sir. Yes, Your Honor. Cole Wilson, the Texas Department of Insurance.
Make sure you focus on the jurisdictional issue that has come up about whether this case, if it's not in our exclusive jurisdiction, whether we have it, what do we do with it if it's not? I don't know if you've read the Kelly versus Humunga decision from the Texas Supreme Court last week, but the gist of it is that we have jurisdiction of cases within our, and my colleagues can correct me, jurisdiction of cases within our exclusive jurisdiction or transferred to us by the Supreme Court in part of equalization transfers, but not otherwise. And so, since this is certainly at least a large part of Chapter 21 case, that's not in our exclusive jurisdiction. So we need your help on figuring that out. And you can, if you're not ready to do that today, we can do that post-submission. All right. So let's see. Mr. Wilson going first?
Yes, Your Honor.
You may proceed.
Thank you, Mr. Chief Justice. May it please the court. Thomas's state law claims under Chapter 21 of the Labor Code all fail in our evidentiary challenge because he failed to submit evidence disputing the department's lawful reason for terminating his employment, that he abandoned his job in violation of agency policy. He says this point is disputed because he disagrees with it, but the conclusory assertion in his affidavit is not competent evidence. As to the ADA and FMLA claims for which this court has jurisdiction, Texas has not waived its sovereign immunity, which extends to the department. Nor did Congress validly abrogate that immunity for claims under Title I of the ADA or the FMLA's self-care provisions. This point is obvious enough that Thomas does not try to defend the trial court's decision on these grounds. Rather, he argues that the trial court denied a jurisdictional challenge to official capacity claims against named government officials who share the same sovereign immunity as the department.
So FMLA is not a part of Chapter 21, correct?
That is correct, Mr. Chief Justice.
Everything else is a part of chapter, disabilities, age, race, religion, sexual harassment, that's all part of Chapter 21.
In part, Mr. Chief Justice, Thomas also brings ADA claims, which are federal claims that are not part of Chapter 21, although they share elements in common given that he's pursuing a circumstantial case under the McDonnell-Douglas framework. And so there's an element shared in common. And if this court wrote an opinion explaining that Thomas, for example, he was not an otherwise qualified employee on a prima facie case, then ultimately, whether this court found that it did not have jurisdiction over the remaining Chapter 21 claims, then at least that claim could be conclusively resolved under law of the case.
But all of these claims are included within one matter, and I believe our jurisdictional statute speaks to a matter. And so when we're looking at whether the matter includes a claim that does fall within our exclusive jurisdiction, it's your position that the matter does include at least one claim that falls within our exclusive jurisdiction.
That's correct, Justice Phillips.
Okay, thank you.
So Thomas argues that he also raised official capacity claims, but he doesn't explicitly mention that he did in his amended petition. So the little we know about those claims are what he mentioned in his subsequent briefing in response to our jurisdictional challenge, where he clarified he was bringing an ultra vires challenge, both to the federal and state law claims. The trial court explained that Mr. Thomas's ultra-virus challenge to the official capacity claims against Ms. Frederick, Ms. Paul, and Mr. Walker could not go forward. It was inapplicable, but that the same challenge could provide for a waiver to sovereign immunity against the department. The problem is that one cannot bring an ultra-virus challenge to a government agency. It can only be brought against individuals. Another way that the
But-
court...
Ultra-virus is not a magic card that overcomes jurisdictional problems. Ultra-virus is a government official had no legal authority whatsoever. And these people, your clients, clearly had legal authority to manage employees at the Texas Department of Insurance, right?
That's correct.
So what was the argument below that they were acting without legal authority? Because it's not enough just to be wrong. They make the wrong call. It's got to be they have no legal authority to make a decision.
That's correct, Mr. Chief Justice, and that's what the Supreme Court of Texas explained in Hall against McRaven. As I understand Thomas to be arguing, a conflict or an erroneous interpretation by the government official that conflicts with some other collateral law, for example here the ADA or FMLA, he suggests is an ultra-virus act. But I think that the Supreme Court's jurisprudence here is clear that it has to conflict with the enabling authority that permits the government official to act in the first place. So there is not an ultra-virus challenge in this case.
Right, this is just a lawsuit against the department.
That's correct. And while it's true that a claim against an official capacity government official is against the entity and not those officials themselves, Thomas clarified that he was only bringing an ultra-virus challenge to the extent he was bringing an official capacity claim at all. And our Supreme Court clarified in Franca against Velasquez that that is the one instance in which an official capacity claim is not against the entity, but against those individuals to bring them in compliance with the entity's enabling authority. Turning to some of the overlap with the FMLA claim and the prima facie elements here, Thomas also discusses how he took continuous FMLA almost a year and a half prior to the Adverse Employment Act that he focuses on. And even if this court finds that the official capacity claims still exist below, but they were not part of this appeal, then explaining that the time between that act and the Adverse Employment Act here, his termination in September of 2021, is too great to provide for an inference of discrimination or retaliation, then that would also resolve that claim upon remand, regardless of whether the court agrees with us that those claims still exist here. As for Thomas's state...
This is the first time I've ever heard of self-care claims under FMLA. Do you get 14 weeks for being sick under a self-care exception? How does that work?
The FMLA provides, as I understand it, the same amount of leave regardless of you're caring for your own injury or disability or harm, or you're caring for a spouse, a dependent, and you're caring for that other person. The distinction matters because in the case of Coleman against Court of Appeals of Maryland, the United States Supreme Court found that Congress had only validly abrogated state sovereign immunity for the claims involving care of another and not self-care claims. And that's because under Section 5 of the 14th Amendment, Congress had only provided for that valid abrogation by showing a state historical practice of discrimination with respect to family care claims and not self-care claims. But Thomas here brings a self-care claim. He had taken continuous FMLA and then intermittent leave of 2 hours each day for a shortened schedule to care for himself after he was recovering from a prostate cancer diagnosis and treatment. So the easiest way to resolve Thomas's state law claims, if the court finds that it can do so, pursuant to its jurisdiction over the ADA and FMLA claims that are part of this same matter, is to focus on the adverse employment acts that he alleges. He focuses on three separate things. Mr. Frederick's workplace comments that were critical of him, but criticism of an employee cannot be an adverse employment action. an August 2nd, 2021 memorandum that was disciplining him, but that cannot be an adverse employment act because he does not dispute that there were grounds for that discipline, colorable grounds at the least. He stipulates and even appears to agree that he was unwilling or unable to perform some of the tasks that were assigned to him, which is the reason for the discipline.
And these are the training functions, right?
That is correct, Justice Ferris. This is the training other examiners function. And although Thomas focuses on arguing that this was not an essential function of his job and therefore could not be a reason for showing he was not otherwise qualified, the Barber case, which is a Fifth Circuit case which can be relied on as persuasive authority, showed that any task that bears more than a marginal relationship to the job is an essential function. Additionally, Title 29 CFR Section 1630.2 N3II, which is an ADA regulation for employment claims, explains that a job description for a posting for that job is evidence of the job's essential functions. And if the court turns to our appendix, particularly tab 2, we have that job description, the general description for which says training and supervising other examiners is some of the work that is involved in the position that Thomas held as Financial Examiner 5. As to Thomas's termination at the end of September 2021, he claims that he did not abandon his job, but he only offers conclusory assertions in paragraphs 25, 26, and 27 of his affidavit, which are not competent evidence, and the Chief Justice explained that in passing in the Arkoma Basin decision, explaining that a statement in an affidavit that doesn't provide the underlying reasons and support that inference is conclusory. And here in those paragraphs, Thomas states that the agency did not comply with its own procedures. He doesn't mention what those procedures were. He doesn't mention how the agency allegedly failed to comply. And so all we're left with is the department's valid reason for discharging him.
What do you make of Mr. Thomas's arguments that what you're essentially doing is requiring us to get too deep into the merits at this juncture? Is there any, is that correct? Is that way off base under our governing precedent here?
Well, I understand that that would be correct as to a pleadings challenge, but not an evidentiary challenge, which is treated the same as a summary judgment motion. And here, the trial court effectively denied our evidentiary challenge by declining or neglecting to rule on it. But as the Supreme Court of Texas explained in Alamo Heights, when a government defendant raises a evidentiary jurisdictional challenge, courts are not free to disregard that challenge and focus only on the pleadings. The court must go beyond the pleadings to analyze whether jurisdiction exists on that evidentiary challenge. Now, even if the court disagrees with everything we've said as to the ultimate elements of Thomas's Chapter 21 claims, we still win because he failed to establish a prima facie case. For his retaliation claim, all he offers in the way of protected activity is in paragraphs 13 and 14 of his affidavit, where he references discussions for disability accommodations. His failure to describe that he ever raised the specter of discrimination means he didn't actually engage in protected activity, because he did not complain of activity that Chapter 21 or Title 7 of the Civil Rights Act federally prohibits. Additionally, he doesn't say when those events occurred, so he couldn't establish causation. As for his disability discrimination and failure to accommodate claim, although we of course concede that cancer is a disability, Thomas simply neglected to develop the record about whether he was still suffering from cancer, how long his diagnosis and his treatment following his continuous FMLA had lasted. All we have here on this appeal on the record is that he said he had medical limitations that his doctor provided to the department. We don't know what they were on this record before the court.
How specific does a person like Thomas need to be? They're obviously recovering from a very traumatic cancer scare. It's a very personal nature. Like, how much does the employer actually have to know in these types of circumstances?
Not much, Justice Ferris.
Okay.
But the issue here is that he simply failed to develop the record. He doesn't even say what that disability was that caused the medical limitations for which he said he couldn't perform certain functions. Now, Thomas does offer that the argument that he was constructively discharged as a way of trying to show that the department's termination decision was pretextual. But as a preliminary matter, constructive discharge is only a way of establishing the prima facie case, not disputing an employer's lawful reason for the Adverse Employment Act. But Thomas also fails to show he was constructively discharged, which is a greater showing than even a hostile work environment claim. The Fifth Circuit explained, and the Third Court of Appeals here in Austin has borrowed these same 6 factors in Gardner against Abbott for how to decide whether or not an employee has even raised constructive discharge. 1, demotion. Thomas does not claim he was demoted. 2, reduction in salary, which he also does not claim. Reduction in job responsibilities. Here we have the opposite. Thomas wanted a reduction in his job responsibilities. 4th, a reassignment to menial work. Again, here we have the inverse. Thomas complained that his work was too complex. He wanted an easier set of work assignments. 5th, badgering, harassment, and humiliation, which more on this in a moment. And 6th, offers of early retirement that would make the employee worse off regardless of whether they accepted. And here the memorandum terminating Thomas shows that he was never given a devil's choice between worse off retirement or returning, but even after he violated agency policy and was able to come back, he was still offered the chance to return to the office and continue his employment, not on worse conditions, but the same. As to the humiliation and claimed harassment, the plaintiff in the Gardner case had 13 separate instances of alleged harassment, and even that was not enough, according to the Third Court of Appeals. And here we have far fewer. If the court has no further questions, I'll reserve my remaining time for rebuttal.
Thank you, Mr. Wilson. Mr. Downey.
Yes, thank you, Justice. I think the best way to approach this is to start from square one, which is the Texas Commission on Human Rights Act claims under the Texas Labor Code. It's very clear that sovereign immunity is waived in the event that basic elements of the claim have been shown in response to a plea to the jurisdiction. In this particular case, I am not entirely sure how the state is claiming that Mr. Thomas was not either A, disabled, or B, that they didn't know about it, when in fact there was very clear communications, and it's clearly stated in the record, discussions between Mr. Thomas and the folks at TDI discussing his need for an accommodation, namely, which was actually granted by TDI, which was to reduce his work hours and to limit his duties and responsibilities.
The problem is we almost certainly can't write anything about the TCHRA. We're an odd court. It's an odd bird. If you bring TCHRA is basically the same as Title VII. One's a state statute, one's a federal statute. The legislature in its wisdom says suits against the state, we have no jurisdiction of Chapter 21 claims, TCHRA, but we do have jurisdiction of Title VII under the Federal Act. Now, so I think it would be very unlikely we would write an opinion on the merits of the TCHRA since we have no jurisdiction of it. Now, I'm not sure what you do when the two claims are exactly the same.
Which they are in this particular case. They are nearly identical.
Well, would we have
well,
jurisdiction?
actually, I take that back. We're in this particular situation, we are not claiming under Title VII, we're claiming under the Americans with Disabilities Act.
Would we have jurisdiction to write if it's within the same matter as a claim that falls within our exclusive jurisdiction?
I would think so. That provide, sure. And I think that that's provided for within within the Texas Labor Code, Chapter 21. Okay. And so consequently, I do believe that, the defenses that they have raised or to claim that somehow sovereign immunity applies, it doesn't apply in this situation. I think we've more than adequately demonstrated the facts to support those claims. As far as the ADA and FMLA, it's a little odd dealing with this in a state court level, to be honest with you. In my 30 years of practice, it's probably the second time that we've dealt with it. However, it's very clear from the case law here that what the judge did was the judge found that, in fact, Ms. Paul, and this is on the fourth page of the opinion, She went through the listing and specifically stated the ministerial duties that these individuals failed to execute within their official capacities, namely, they failed to engage in the interactive process under the FMLA, or ADA and FMLA. They interfered with the ADA and FMLA leave that was granted. They retaliated based on, or they potentially retaliated based on FMLA assigning more work than at least one could perform under his or her approved FMLA schedules. Those are all clearly ministerial acts. So consequently, again, the case law is pretty clear that sovereign immunity is not going to absolutely apply to those situations, as the district court judge rightfully decided.
As to the individuals, though, right?
In their official capacities, yes.
Right. And that's what confused me, honestly, in reading the briefs. I felt like I was reading two different appeals. Because the only appellant is TDI, right?
Correct.
So I can't figure out for the life of me why we're talking so much about the individual actors and whether they were acting in their official capacity and had a ministerial duty, because what does that have to do with any claim against TDI?
Because the sovereign immunity TDI is not able to apply sovereign immunity to those claims based on the fact that there are ministerial duties being carried out by officials in their official functions.
Well, wouldn't those people have to be parties then?
Well, and the thing is I believe that the judge has, the judge has said, yes, they are removed as individuals, but they are not removed as individuals in their official capacities. I think that was parsed out within the order very clearly, because she has clearly stated that the actions taken by these individuals were in their official capacities.
Right, but how does that make the claim against TDI?
Because it waives the sovereign immunity issue, or it overcomes the sovereign immunity issue.
It does for those individual acting in their official capacities, but how does it for the entity itself?
The case law is clear that the causes of action, or the court still has remedies with regard to TDI to ensure and to enjoin and to take other equitable actions against TDI for the actions that were in violation of their ministerial duties. So TDI is still liable for their actions. They were acting within the course and scope of their job. So as an employer, if an employee is acting within the course and scope of the job, with the exception of maybe sexual harassment and maybe a couple other individual liability situations, the employer is responsible. And that's what we're talking about here, is that the employer is responsible for these actions of these individuals.
And I recognize it gets difficult in the ultra-virus context, because I recognize it's confusing in that you're suing the individuals in their individual capacity, but your remedies are really, it's not clean, because your remedies really ends up against the entity.
Correct.
But yet we've got case after case after case saying in an ultra-virus situation you can't sue the entity. It doesn't waive their sovereign immunity.
Well, but I think that's where the case law comes down to say is, in fact, that you can continue a cause of action against the entity for the actions of these individuals that violated their ministerial duties under these statutes, and that sovereign immunity is waived with regard to that. So I think
So just taking, for example, I'm just trying to think of different ultra-virus claims, Hall versus McRaven. You're saying Hall should have been able to pursue a case against the University of Texas?
With the actions of the official capacity where there's a violation of their ministerial duties. And again, this is another factor, is the ministerial duties. It's not just a discretionary duty versus a ministerial duty. In this case, there was a ministerial duty for these individuals to follow the application of the law with regard to the ADA by providing reasonable accommodation, follow the law with regard to the FMLA, and granting and allowing for the leave of absence and the intermittent leave that was requested and approved by the state. So the state actually approved, and it says FMLA leave. So the fact is that the state is actually recognizing the application of the FMLA in the employment setting to this individual, and by the violation in their official capacities of that rule, there should be liability against the state.
Can you point me
And
to
it
a,
should,
can you point us to a case on an appeal where they've been, in this situation, has been allowed to go seek direct action against the entity rather than the individual actors?
I believe I've cited a couple in my briefing, and to be honest with you, I apologize, I'm completely drawing a blank on what those cases are, but I'm
But
happy
it's
to
just the cases in
draw
your
them.
briefing?
Yes.
Okay, thanks.
So help me, I know you haven't necessarily read this new opinion, but, so treat this as a hypothetical. Assume our court hypothetically has jurisdiction of TCHRA employment discrimination cases, exclusive. Nobody else has it. And assume our court does not have jurisdiction of Title VII federal law claims, and the two are assumed, as you're allowed to do, you can plead both. So appeal comes to us, what do we do with it?
Well, I think that the traditional case law, as counsel has pointed out, so the way that the case law had traditionally been treated is to say if a plea to the jurisdiction is brought where sovereign immunity is raised as the defense by the state, which is exactly the situation in this case, that it is then that the plea to the jurisdiction is then actually treated more like a motion for summary judgment. And that's what they're saying then. That's why they're going back to, hey, what does the record show as far as the evidentiary factors and why they're talking about prima facie cases and pretext and all these things. So that's why they're deferring back to these things, is because what the motion, or for the plea to the jurisdiction is treated as then is a motion for summary judgment, which, as we know, the standards for motion for summary judgment are, is there any evidence of each of the elements, or is there a material fact shown for each of the elements of the claims? And in this case, our position is absolutely. And, you know, this is where we get into, is there a disability? Was he qualified for the position? And was there a pretextual action taken by the employer in the case of the straightforward discrimination?
So let's say you do both Chapter 21 and Title VII cases, you win or lose on both of them. Would you prefer a system in which we split that case on appeal and we get the Title VII case and Third Court of Appeals or another Court of Appeals gets the Chapter 21 case? Or
No, I think that the jurisdiction would all lie within the same court. I don't think that there's I see no basis in the case law to be splitting these cases out.
would you object if one court or the other said, we'll take it?
No, I don't think that there would be a basis for that.
Don't it? No, you're supposed to say, that depends on who the court is, right?
Well, it probably does depend on who the court is. But, Your Honor, looking at the situation to say, again, the split between the state and the federal, yes, I'm surprised with the fact that we pled federal claims.
Sure.
I get removed all the time. And so I'm up in federal court, and there's never any real question as to
Right.
jurisdiction.
They have
The fact is-
pendant jurisdiction. and-
Exactly. So I believe that Your Honors have the authority to rule on all of these cases. And the thing is that I think the case law is also very clear to say that, you know, you can pull from federal case law to apply it to state law where they have similar claims. And in this particular situation, I think ADA and Chapter 21, with regard to disability discrimination and reasonable accommodation, are nearly identical.
And before we get too far down into your time, could you respond to the allegation that the accommodations that your client requested here were not specific enough, were conclusory, and that they also dealt with basically essential functions of the job?
Sure, absolutely. With regard to the essential functions, I think it's very simple that we look at the record at page 164, and there's a job description here. And it clearly says essential functions of the job. and it lists out under a number of bullet points the exact essential functions of the job. And the closest essential function of the job that, with what they're claiming is he did not train, he was unable to train individuals because he received a huge assignment otherwise, on top of the fact that of his limitations on his time due to the approved FMLA intermittent leave that he was receiving.
So is there evidence in the record that, of kind of how those two are related? Like, is a training so long that it can't be accommodated with his limited hours, or what is it specifically about the training that?
Yeah, the interesting thing on that is we would probably have to get into that if he actually had been assigned any training. But he went to the manager and said, I don't want to do training. The manager said, fine, you don't have to do training. So in this situation, it's kind of like, well, wait, is an essential function of the job that he was supposed to be doing it and he didn't, it's not a matter of he didn't do something that he was assigned to do. He simply said, hey, my limitations are limiting the amount of time that I can work in a particular day, and that limits my ability to work on this major assignment that you've given to me and to also do this training. I mean, he's already, the record does clearly state in the affidavit that we submitted where he talks about very clearly that he said at the point that he was given this huge project, he goes, wait, this project is bigger than even just me, and requested numerous times to say, hey, I need more help on this project. They refused to give it to him. That doesn't even consider the fact that on top of saying, hey, wait, this is a huge project, I can't accomplish this, and the facts are very specific within his affidavit to discuss this. This is why I say conclusory. I'm not too sure where they're coming up with that argument. But he clearly says that, hey, this project is too big for me. On top of that, this project is really too big for me, given the fact that I'm continuing on FMLA intermittent leave that has been approved by the state. I have been approved for limited, I believe it was 6 hours of work on a daily basis. You've given me this huge project that's going to take way more than 6 hours a day to accomplish it.
Well, was his specific accommodation like you never have to train anyone, period, or
No.
this particular?
No.
Okay.
This was a very limited situation. This was a limited situation to the time period, and I think we spelled that out within the affidavit. It was a particular group of new investigators that were coming in, and he simply said, hey, can I, because of my limitations on my time, and I've got plenty of work to do otherwise, can I be kind of let off of doing this job? And they said, and it was never assigned to him. So that's another argument to say, in addition to the fact that it's not showing up on the job description as an essential function to do training, the fact of the matter is that he was never asked to do the training because he requested not to do it, and so they didn't assign it to him. So he's not refusing to do some job that he's been assigned to do. It is a matter of, it's not an essential function, we don't believe, based on the job description that they submitted in the record, and then B, like I said, it wasn't ever assigned to him. So obviously it wasn't too essential to his job if he was able to still do his job, and not do that particular responsibility.
And if I could also ask about the reprimand memorandum, is it conceded that the reprimand memorandum was justified, and that was, help me with that.
Well, the interesting thing about no, it is, actually it's not conceded. As we discussed in here, the initial reprimand email that was sent to him said, do not participate in activities that are unnecessary to his job. And he's sitting here saying, look, I'm asking for clarification on a couple of the responsibilities that you've assigned to me with regard to this particular project. In particular, I believe there was some meetings with, I can't remember, examiners or somebody like that were supposed to be taking place on a bi-weekly matter, which was a unique situation to that particular project. And so he was simply asking for clarification, and the response was, do not participate in unnecessary conversations. So yes, we are absolutely disputing. We're saying that that action by them was, not only retaliatory, but evidence of at least a negative attitude towards his accommodation needs and his disability needs and his limitations. Because they're just coming after him and not answering a simple question that he's asked about how to do his job on a day-to-day basis. So yes, we are disputing that. And I think too, that it's clear in the record that there's a memo that's put in as the termination of employment. I believe it's record page 168 through 170, where there's a specific discussion about this fact that, that he is absolutely disputing this fact, and that he is that Mr. Thomas has actually raised, I apologize, that he has actually raised a complaint with not only his original ombudsman HR person, a gentleman by the name of Chris Polk, but then he subsequently raised the complaint, a similar complaint again, discussed very clearly again in detail in our affidavit with, he first reached out to Curtis Polk to discuss the matter. Then he reached out to Cynthia Oliver, the Deputy Commissioner, and Deputy Commissioner Jamie Walker, to raise his complaints of discrimination and the issues that he was having with Mr. Frederick and Ms. Paul, who were the ones that were assigning him work, and had submitted this memo to him saying no unnecessary discussions. So, and then on top of that, it's in the record as well that there was an issue and a complaint made to the General Counsel of TDI, Robert Rucker, discussing exactly that again, these details of, hey, I feel like I'm being discriminated against, I feel like I'm being harassed. So consequently, again, when we get into the issue of retaliation, their claims that he didn't make a complaint is beyond us.
Thank you, Mr. Downey. Any
Thank you
more
so much.
further questions? Thank you, sir. Mr. Wilson, 5 minutes.
Thank you, Mr. Chief Justice. If the court would like supplemental briefing on the jurisdictional question, I'd be happy to provide it, and I'd
Yeah,
appreciate the
it's-
opportunity.
Well, we were, we didn't know it was coming out either, but it's two issues. Number one, do we have jurisdiction of FMLA as well as Chapter 21? I think FMLA is not excluded. Chapter 21 is, but if there's some way we have jurisdiction of both or not, and if we don't have jurisdiction of both, what do we do with this case? Thank you.
But to answer the court's hypothetical, I would object to the court severing the case or refusing to exercise jurisdiction if it could over part of the case. And it doesn't seem prudent to sever claims that
That are identical.
Right, so
that are identical.
you would say that if there's one claim within our exclusive jurisdiction, within the matter, we have jurisdiction over the matter.
That is exactly right, Justice Ferris. That's
So
what we
if
would
you can
encourage.
get us some authoritative cases from your department, that'd be helpful.
I would love the opportunity. As to Thomas's suggestion about removal, of course, removal would not have happened because a government entity waives its sovereign immunity challenge to jurisdiction under a 12b1 in federal court if it removes the case to federal court. So that, in some part, provides some context for why that decision wasn't made. As to the argument from my friend about whether or not Thomas was assigned to train other examiners, in paragraph 7 of his affidavit, he explicitly says he was assigned to train other examiners by Ms. Paul. Quote, Ms. Paul told me I would also need to assist in training newly hired examiners, in spite of my request to be exempt from such training responsibilities given my medical limitations. Now, it's true that the job description says there's a separate section for essential functions, but there's also a basic description. The essential functions includes other work as assigned. And the basic description explains that this is work involved for a chief examiner 5 that was assigned to Mr. Thomas, and he failed or was unable to perform that function, and therefore he was not an otherwise qualified employee. As to the case of Halgins McRaven, I think it is important to at least understand what that case is talking about. There, the plaintiff alleged that the defendant's interpretation of FERPA, federal privacy law for educational privacy of students, was wrong and thus ultra vires. but our Supreme Court disagreed, explaining that McGraven's enabling authority directed him to decide whether or not the regents of the UT system could review information protected by FERPA, but did not constrain his discretion. And even if his interpretation of that federal law was clearly erroneous, it is still not ultra-virus under our Supreme Court's jurisprudence. Ultimately, if this court were to write an opinion agreeing with the points over which it has jurisdiction and trying to cover as much ground for the ADA and FMLA claims that would also share some commonality with the Chapter 21 claims, then ultimately we could resolve all, or most if not all, of the claims that are involved on this appeal, even though Mr. Thomas's counsel claims that some of them are still in the trial court. One other thing bears mention, an ultra-virus challenge, even where it's permitted, similar to an ex parte Young challenge, is limited to prospective injunctive relief and not monetary damages. So even assuming Thomas had a viable claim, and even assuming he could bring such a challenge, he would be limited to reinstatement. And reinstatement is only available where it's feasible. And if the department showed upon some hypothetical remand that it was infeasible, Thomas would not have an alternative remedy for front pay, which is monetary damages, even if equitable. So he would be left with nothing. We ask this court to reverse the decision below and enter judgment for the department. Thank you.
Thank you, Mr. Wilson. If you all could try to get those in for us within a couple of weeks, that'd be very helpful. So the court will take a brief recess, back 7 minutes.
All rise.
seated, please.
Next case is TCEQ and Guadalupe-Blanco River Authority versus National Wildlife Federation. All parties ready? Let's see, is it Ms. Hobson? You may proceed.
Thank you, Your Honor. Good afternoon, and may it please the court. This is an appeal of a water use permit issued by the Texas Commission on Environmental Quality to the Guadalupe-Blanco River Authority under Chapter 11 of the Water Code.
Pull the microphone just a little closer, if you would.
Chapter 11 is the statute that sets the terms that govern when someone can access state water for a beneficial use. It balances those rights of access with the need to keep environmental flow in the streams for environmental purposes.
It's still a little hard to hear you. I don't know if you can.
It's the air conditioner, it's a little.
Yeah,
I have one of those voices.
that's better.
Okay, I'll kind of lean this way. The statute does not direct, outside of that context, the agency to regulate construction projects. So with that backdrop, I'm going to address two main points. One is about the diversion of state water. TCEQ was right to apply the environmental flow standards in assessing the environmental effects of this permit. That's what the legislature directed it to do. Two, I'll address the off-channel storage of water. The legislature has not directed TCEQ to regulate any off-channel storage through Chapter 11. So TCEQ applied its laws and regulations correctly in granting this appropriation, and that is why the permit should be upheld. GBRA's counsel is going to introduce GBRA and talk about this permit a bit, and then we'll walk through how the protestants cannot trace the errors they allege to their substantial rights. And of course, I'm available to answer questions on other topics as we go. So let's start with Chapter 11. It's a state statute. It has no federal corollary. Its sole goal is to manage the use of surface water, which in Texas is a state-owned resource. It's, of course, a crucial resource, one that we don't always have as much of as we'd like, and it's necessary for all kinds of purposes, including municipal purposes like drinking water. That's how most of us encounter what was once state water, is when we turn on the tap. It's also necessary for agriculture, industry, etc. Chapter 11 is a statute that charges TCEQ to manage our supply of state water, balancing these sometimes competing needs. And it does that through a permitting system that allows applicants to apply to use the water and put it to beneficial use. In this case, to take it out of the water course and use it for one of the uses allowed under the statute. GBRA applied for municipal and industrial uses. So how does TCEQ determine how much water needs to be left in the water body for environmental purposes? In the past, TCEQ conducted a site-specific habitat assessment for every appropriation of water over 5,000 acre feet of water. Then in 2007, the legislature made a change. It decided to protect freshwater inflows, that's flows to a bay, and in-stream flows in a river, comprehensively. And that means protecting the flows for the entire water system from headwaters all the way down to the bay and every point in between. It required the commission to adopt environmental flow standards, e-flow standards, for certain basins and to use these standards instead of the site-specific habitat assessment under 11.152.
And where's the instead of language?
If you look at the handout that I provided for the court, it's our little oral argument exhibit. That first page, it's in 11.147E3. The commission shall apply any applicable environmental flow standards instead of the factors in subsection E, which requires a consideration of an assessment under 11.152. So that's where that language comes from.
But isn't that provision E3 a little inconsistent internally? I mean, it says, well, let me back up. Isn't the whole purpose of E3 to describe what to do when determining environmental flow conditions?
Yes, it is. And yes, environmental flow conditions are what 11.152 was aiming to accomplish as well. So to look at what 11.152 was meant to do before the e-flows regime came into play, we have to look at its context within the statute. And that 11.147 provision that's on your handout is a good example of this. 11.147E directs the review at 11.152. The heading of that subchapter is the effects of the permit on bays and estuaries and in-stream uses. So the focus of Chapter 11 has always been, how do we preserve in-stream uses for either the beneficial use of people or the environmental needs of the stream? So there's a seismic change in terms of how programmatically TCEQ is going to go about protecting those in-stream uses, but 11.152 has always been about the in-stream needs of Texas water bodies. Does that help?
I mean, it does, it's just it seems like, I mean, even 11.134B3, it seems like that conflicts with your interpretation, because there we have a provision in the same chapter that talks about environmental flow standards and then says, and if applicable, section 11.152. So it seems like the legislature there is still saying you could have both. Why would that not be inconsistent?
If it's possible to have both in a hypothetical situation, that's not the situation we're in here. Because here, it is a straightforward diversion of water from a water stream in an efflows basin and an off-channel reservoir, which has not ever been within the realm of what Chapter 11 covers. So is there a situation where they could both apply narrowly under specific facts? I'm not sure of the answer to that, but we don't have to get to that here. So if I could zoom out a little bit, when we read the policy section in Chapter 11, that's a great encapsulation of the statute's focus. It lays out three main points. Waters of the state are held in trust for the public. Maintaining the biological soundness of our waterways is of great importance. And the Commission must balance all their public interests to consider and to the extent practicable to provide for freshwater inflows and in-stream flows necessary to maintain the viability of the waters. So the statute's focus, Chapter 11, is about maintaining the viability of the streams of Texas. The focus on environmental impacts are all related to the presence or absence of water. And if I could briefly move to the off-channel reservoirs argument, with that backdrop, that's the argument that has nothing to do with the diversion point. It's what happens to the water while GBRA is storing it for a future beneficial use. So it happens off the channel, it is not involved in the stream.
So this is all post-diversion, basically?
Post-diversion. Neither the EFLOW standards nor the site-specific habitat assessment have ever applied to off-channel reservoirs because those are not an appropriation from the water course. And again, the statute's concerned with this question, can the Guadalupe River Basin withstand the appropriation that's being applied for here? Can the stream take it? Considering all of the other rights that have been appropriated here, considering the environmental needs of the stream. Once that question's been answered, it doesn't matter how GBRA stores that water off-channel before it puts that water to beneficial use, whether that's in a tank or underground or in an above-ground pool, none of those options will change the answer. And so that's why 11.152 has never applied to off-channel storage reservoirs.
So you're saying if the flow conditions are such that the flow would not be impacted to too much of an extent, that also subsumed in that is the protection of any wildlife involved in that?
Right. The legislature took terrestrial and aquatic wildlife needs into account in developing the EFLOW system.
Then why does the one statute about environmental flow standards only mention aquatic wildlife and fish?
Well, it's a good question, and I think it's often the case that when we're thinking about flow of water and availability of water, we tend to think of aquatic wildlife. But the Science Advisory Committee that the legislature prescribed to be put into place was required to have experts in both terrestrial and aquatic biology. So the needs of wildlife writ large were taken into account in developing the environmental flow standards.
Thank you.
Thank you.
Ms. Perales?
Thank you, Your Honor. Good afternoon, and may it please the court. Before I address the procedural aspects of this case and introduce you hopefully to the Guadalupe-Blanco River Authority, or GBRA, I'd like to take a moment to follow up on some of the lines of questioning that you had with my aligned counsel. Justice Field, you put your finger on it with 134B3 and the and also with the question about aquatic. Is there a world in which an appropriation of state water could be in an environmental flows basin and still have some element of 11152 assessment? It is not our case, because the way that GBRA is seeking to take water, to appropriate water, is putting a straw in the river and taking that water out. So that's really about the environmental flow. But you can think that there's another way to take state water, to appropriate it, and that's if you stick a dam across a river. You would be flooding the banks. You would be doing something that is both non-aquatic, and so that's that and. So you get the environmental flows for the aquatic, but you also have the and of 11152 in the unique circumstance that you have an on-channel reservoir in an environmental flows basin. Again, that's not our case here, because that's a dam across a reservoir inundating. Here we have a straw in the river taking that water, and as Justice Ferris, you noted, anything subsequent to that, whether GBRA stores it in a bucket or in an above-ground storage tank or below ground in an aquifer, that's all subsequent to the appropriations, that post-diversion action.
And I think that's a really, I like the picture of the straw. My problem is, where is that in the statute? Like, I understand what you're saying, and that makes intellectual sense, but where, I don't see that in the statute.
So what you're looking for is some indication of the legislature saying, this is what Chapter 11 is.
Like, we can completely we can disregard everything other than flow here, but we can't here. I don't see that at all.
So what you're seeing is the tension between a relatively new statute, that's the Senate Bill 3, the environmental flow standards.
Kind of like our jurisdiction. Yeah.
It's actually older, fortunately, and we don't have case law from last week, also fortunately. But what we have is a statute from 2007, and this case really is the first chance for an appellate court to construe what the environmental flow statutes mean in the context of Chapter 11. But the thing that has always been clear, and Texas water law is quite old, and it evolves very slowly, is that Chapter 11 has always governed state water and water courses. That's in the record. That's everywhere. The testimony of TCQ's expert says that. The Commission's actions have been consistent with that. And that is what you see throughout the case law, is state water and water courses. That is the province of Chapter 11, and not anything subsequent to it. So could there be a hypothetical situation in an environmental flows basin where there might be some additional 11152? Potentially. But that is not this case. This case is a straw in the river and then subsequent actions to put it somewhere else for storage.
And I hate to wade into a hypothetical, because I know I'm going to get it wrong, because I don't know environmental as well as you do. But, you know, theoretically, could the diversion of water affect the salinity in a bay to the point that the salinity becomes too high for aquatic wildlife, or perhaps other wildlife that feed on aquatic wildlife? I mean, why couldn't you have, besides the dam, why couldn't you have a situation where taking water from a water course and putting it in storage actually does have an effect downstream on riparian wildlife?
Because in this instance, Your Honor, there is the environmental flow standards in place, and this permit, they're undisputed finding of fact 82 and 83, that this permit properly applies and implements the environmental flow standards. Finding of fact 83 is specific to the flow standards for the bay. The San Antonio Bay's salinity and that flow and all of that were protected by rule, and by this permit properly applying and implementing that duly adopted rule directed by the legislature very prescriptively, and notice and comment and basin and bay stakeholder input, all of that says that this diversion will not cause the salinity to harm the soundness of the ecological environment at the bay or fisheries. That's already part of the rulemaking, and this permit properly applied it. But this is a very good question, because again, it's a new statute, it's new rules. This permit actually was issued in draft form less than a year after TCQ adopted those rules for this basin, and it is the first time, and the parties worked very closely together for a very long time to negotiate and put into an operable new water right, environmental flow standards. It's why the record says negotiated draft permit. The NDP is the product of that negotiation, and it was months and months with multiple parties. You'll see in your bench book there's a map. The squares on that map are hearing requesters whose interests were either determined not to be affected by this application or who settled with GBRA. There was a lot of involvement, and NWF's members' asserted interest in environmental flows is squarely on the bay. It's actually just off the corner of your map down at the southeastern corner, a little bit further in the bay. And it's about 100 miles between the diversion, the straw in the river, to that member's affected interest. And for that reason, on the procedural side, we say that NWF has not articulated prejudice to its members' substantial rights, even assuming that those are substantial rights, so as to obtain reversal of this water right. The environmental flows were implemented properly, and NWF doesn't contest that. And for that reason, we don't see any grounds for reversal.
Thank you, Ms. Perales.
Could I ask one question on the other topic that?
Yes, Your Honor.
Yes, could you tell me your response to the Hooks versus Texas Department of Water case and how that impact? I mean, because that's Texas Supreme Court 1981, and how does that impact your position here?
Yes, Your Honor. And GBRA does contest NWF standing under 2001-171 for the reason, and Hooks talks about the idea that the statutory standing also includes concepts of justiciable interest and kind of the general principles of standing that we think about. And for that, it's about whether there is an injury that is redressable, and for the same sorts of reasons that we contend that NWF has failed to show prejudice to its substantial rights from actions or inactions 100 miles away in Gonzales County. We also have trouble seeing how their injury that they allege is redressable by this court from any actions that you might change in Gonzales County. Again, the permit properly applies and implements the duly adopted standards, and we don't see that connection. And for that reason, we do contend that they lack standing, but we stand upon our briefs in that.
Thank you.
Thank you, Your Honors.
I'm sorry, that was Mrs. Broadaway, right? Ms. Perales.
May
I
it
should have
please-
had my glasses on. You may
Good
proceed.
thing I brought mine. May it please the court. This case isn't as complicated as the appellants have made it sound, and in fact, it can be distilled into 3 questions. Is an assessment of impacts to fish and wildlife habitat necessary before TCEQ may issue a water right permit authorizing diversions and impoundments? Relatedly, must a water right permit applicant identify the location of the proposed diversions and reservoirs before TCEQ issues that water right? And finally, where, as here, the locations of those proposed diversions and reservoirs have been withheld, is reversal and remand an available remedy for a membership organization challenging the permit by judicial review? We contend that the answer to all 3 of those questions is yes. My friends, the appellants, they say no to all 3. To answer these 3 questions, we need to look only to 3 pieces of information: the water right permit itself, the TCEQ's final order, and the relevant statutory language. And in this case, that would include sections 11.152, 11.147, and 11.124. Based on this information, we know that the water right permit at issue here involves both the diversions and at least 1 proposed reservoir, neither of which could be accomplished without the water right permit that's at issue here. And we know that that water right seeks more than 5,000 acre feet. In fact, the proposed diversion is for more than 75,000 acre feet, and the reservoir or reservoirs will have a storage volume of 125,000 acre feet. And just to give you an idea of the size of that, if it's 1 reservoir we're talking about, and if that reservoir is 50 feet deep, that's a 2,500 acre reservoir. If it's 100 feet deep, that's a 1,000 acre reservoir. So we're not talking about a small piece of land. And within that acreage, who knows what's there? We could have wetlands, we could have pristine riparian forest. Any of these habitats, any of these naturally occurring habitats would be obliterated because we would be imposing a brand new footprint within that area. We know that no assessment of impacts to fish and wildlife habitats have occurred, neither for the diversions nor for the impoundments, because GBRA didn't identify the locations of the proposed diversions or impoundments, or even how many will ultimately be constructed. Now, if we look to the relevant statutory language, and if we start with 11-152, the statute plainly requires an assessment of the effects of issuance of the permit on fish and wildlife habitat. And the commission can then require some mitigation based on that assessment and on guiding principles. The only prerequisite to the applicability of 11-152 is that the permit must be one that authorizes the diversion, storage, or taking of more than 5,000 acre-feet of water per year, and we have that. So why didn't TCEQ conduct the required assessment under 11.152? If we start with the on-channel reservoir, we find the answer to that in the final order, in the plain language there. The commission said that the statute doesn't apply to impacts that are not on the watercourse. And they cited to the Supreme Court's decision in Texas Citizens for a Safe Future and Clean Water for support. And the way that they applied that is they said, quote, when a statutory scheme is subject to multiple interpretations, the enforcing agency's construction should be upheld if it's reasonable and in harmony with the statute. There's a couple of problems with that explanation and with the reliance on that case. First, Texas Citizens stands for the proposition that when a statutory term is subject to multiple understandings, then agency deference may be appropriate. And in that case, the statutory term was public interest, and the court determined that the phrase was anything but clear and unambiguous.
But I don't hear them to be arguing, I didn't ask that question, but I don't hear them to be arguing that the statute's ambiguous or open to multiple interpretations. What I hear them arguing is that 11.147 subsection E3, these things just kill you as a court when they do these statutes with these kind of subsections. But what they're saying is E3 takes it out of section 11.152. And what's your best argument against that? Because the beginning of that section says notwithstanding subsections B through E, and E specifically adopts section 11.152.
Sure, thank you. The first response I have to that is that the commission's interpretation of an ambiguous term, were there one presented here, is best described in either a rule or a formally adopted opinion, not in arguments or briefs presented to a court. And so that's why I first pointed to the language that is in the final order that the agency adopted, because in their explanation, they define the reasons that they determined that 11.152 doesn't apply to off-channel reservoirs, and the reason that 11.147 doesn't apply to off-channel reservoirs. So the focus of my argument was on the language that was provided in that formal decision following a formal proceeding. You're right that in the appellate briefs presented to this court, we have a different argument, or at least another argument, and that is that that 147E3, which addresses environmental flow standards, displaces everything. Displaces not just the provision 11.147E, but also goes all the way back to displacing the broader assessment that is contemplated by 11.152, even for off-channel reservoirs. The problem with that is that's not what the statute says. And it wouldn't have been that difficult for the legislature to have clearly stated, instead of applying the assessment that's required in 11.152, we are applying 11.147E3. Moreover, 11147E3 is limited to flows. We may dispute whether that means that environmental flows displace any assessment for diversions. We think E3 doesn't, but it certainly doesn't displace any assessment required for off-channel reservoirs, because an off-channel reservoir is off the water course, it's off the channel. And so there are no environmental flow standards that are going to be implemented for that off-channel reservoir, even though habitats will be impacted, and even though TCQ's rules and 11152 all provide that assessments of those impacts are required. Does that answer your question, Your Honor?
Yes, thank you.
I'll just briefly go back to the language that was in the final order where the commission relied on Texas citizens to note that, again, there's a reference to a statutory scheme, but there's no term that's identified as being ambiguous, and that's one problem. And the other problem is with the commission's reliance on Texas citizen is that the Supreme Court has repeatedly held that agency deference does not replace strict construction of a statute, especially where, as here, the dispute is not about how to interpret an ambiguous term in a statute, but rather about whether that statutory requirement applies at all. So if we look at the language in the order, the commission states that its interpretation is intended to actually limit the applicability of section 11152. Conclusion of law 27 states that the section does not apply to impacts that are not on the water course. In the explanation of changes in the final order, it states that the scope of section 11152 is limited to impacts on the water course, not off-channel reservoirs. This is an unreasonable construction. As the Supreme Court explained in a number of cases, including Southwest Royalties versus Hager and in Gabriel Investment Group versus TABC, the proper inquiry here is not whether the scope of a statute is ambiguous or whether the statutory language creates unexpected results, but rather whether the statutory language itself contains an ambiguous term. And here there is no ambiguous term. And so the reliance on Texas citizens is misplaced, particularly when we're talking about off-channel reservoirs, because there's simply no distinction in the statute there. As you mentioned, the briefs present a different argument. The appellants present a number of reasons in support of the argument that 11152 should be limited in its scope and shouldn't apply to off-channel reservoirs, and to the extent that diversions need an assessment, those are covered by e-flow standards. But none of those arguments are based on the plain language of the statute, and so none of those arguments are really relevant here.
Let me ask you, under your interpretation of 11.147E3, under what circumstances would an environmental assessment under 11.152 not be required for a water use permit?
So I think that an example would be where we're not proposing a new impoundment. It's potential, even here, we have a diversion and the final permit includes non-flow related mitigation in the order, in that it includes entrainment and impingement measures. So even a diversion would seem to implicate an assessment of the impacts of the diversion on habitat. Certainly an on-channel reservoir, I think that's been conceded that an on-channel reservoir would require an assessment of the impacts on habitats. I think if the diversion or the reservoir were less than 5,000 acre feet.
And I should have mentioned that in the hypothetical. 'Cause that's by statute. We don't have to have one there. But is there anything above 5,000 acre feet where you can think of an example of where it wouldn't be required?
There's not one coming to mind. There's not one coming to mind. But I suspect that at any time that we're talking about an impoundment, whether it's off-channel or on-channel, particularly one that's over 5,000 acre-feet, we've got to look at the impacts, because even if it's on-channel, it's going to affect more than what's on that water course. It's going to extend beyond that and impact other habitat, including terrestrial habitat.
Well, not fish habitat, if they're putting it into a brand-new hole in the ground.
For an off-channel reservoir,
Right.
that's right. The diversion could, but that's right. The off-channel reservoir, unless there's already a stock tank,
mean, you
that's,
know,
if there's a
Never say there's not
right,
something down
or
there.
if there are wetlands, there could be some impacts, but I take your point. So the issue here is not about impacts on water towers, nor is it about impacts on distribution lines. Here we're not talking about the environmental flow standards, not about the process by which they were adopted, not their effectiveness, not whether they apply here. The issue is not about the definition of the term appropriate, because the term doesn't even appear in the relevant statutes. The only reason those terms have even come up in the conversation is because these are among the various reasons that the appellants have presented in an attempt to justify TCEQ's failure to comply with the plain statutory requirements. So
let me take you back to my question for a second,
Sure.
because I'm still puzzling over it. So if there's not a situation you can think of where 11.152 wouldn't apply if it's above 5,000 acre-feet, then what does 11.147E3 mean
sure.
when it excludes consideration of subsection E?
So E3 is intended to address the impacts from flows, so environmental flows. So, and as I think we heard Ms. Broadaway mention, before we had environmental flow standards adopted, that was a site-specific assessment. Now that we have environmental flow standards that have been adopted, and they were adopted as part of a study group that looked only at flows, only at environmental flows, that portion of the assessment has now been replaced by the environmental flow standards. But there are other habitats and there are other impacts to those habitats outside of that flow regime. And so in response to your question, the impact of the adoption of environmental flow standards and the impact of 147E3 is that part of that assessment has now been replaced by E3. And it's possible, it's certainly possible, I'm just not thinking of the example right now, but it's certainly possible that TCEQ could evaluate a permit application for a diversion, and based on that assessment determine there's actually no impacts on the habitat that are expected to occur here and no mitigation is required, and the environmental flow standards take care of any environmental flow concerns we may have had, and end of inquiry. I just don't think we have that situation here, and certainly we don't have the assessment that was required to make that determination. Kind of lost my place, but I wanted to just quickly point out that, we were talking earlier about recent court opinions, and the Supreme Court came out with a new opinion just last month that is relevant here, the Port Arthur Community Action Network versus TCEQ. And that was an opinion that was answering a certified question from the Fifth Circuit, and it related to precisely the question that we face here, which is when you have unambiguous statutory terms, in that case it was BACT or best available control technology, which the court determined was actually unambiguous, then you don't defer to other tools. You don't look to some informal interpretation in a legal brief. You don't look at the Code Construction Act, but instead you give effect to the plain language. And in that opinion, the court cited to Justice Willett's opinion in Bank Direct Capital Finance versus Plasma, which is also very instructive on when Code Construction Act tools are are allowed or useful. And in this case, they wouldn't be because we have clear, unambiguous language. I see I have only a couple of minutes left, and so I wanted to make sure I addressed the challenge to whether our substantial rights have been prejudiced by the errors here. And so I'll quickly address that unless there are other questions. Okay.
That's fine.
So in the cases that have been presented or relied upon by the appellants, the courts have considered that provision of the APA, whether substantial rights have been prejudiced, as a harm analysis. It's akin to a harm analysis. That is, did the errors that were alleged materially affect the outcome of the proceeding? Did they result in an improper decision? And in this case, the answer is yes. And NWF was harmed by the errors alleged in their petition. NWF is the party here. They're acting on behalf of their members, which includes more than Mr. Blevins. And because GBRA failed to identify the location of the proposed reservoirs and the diversions, and because TCEQ failed to enforce that required statutory requirement and regulatory requirement, NWF has not had the information necessary to identify all of the members who might be impacted by the proposed impoundments and the diversions. And this in itself illustrates how NWF and its members' substantial rights have been prejudiced. In addition, the ALJs in their PFD had at least proposed requiring GBRA to amend its permit once it had identified the locations of its proposed impoundments and its diversions. But TCEQ in the final decision removed that provision. And so now NWF and its members will not have the opportunity, not even later on in some subsequent permit amendment proceeding, to determine who is the most impacted by wherever those proposed impoundments or diversions are eventually to be located. And they will not have the opportunity to participate in any future decision-making process. And so here we have just a stretch of a river, about 37 miles, where the diversions are proposed to be located, and we have all of Gonzales County listed as the proposed location of the impoundments, which is about 1,000 square miles. Even if NWF had named all of the members that are residing in Gonzales County, it would still be impossible to identify with precision how and who those members, how they'll be impacted by the proposed diversions and reservoirs, because we don't know where they're going to be located. But what we do know is that there are still legitimate concerns about flows into the bay, freshwater flows into the bay, and that was a legitimate concern that was raised by Mr. Blevins at SOA when he testified. And we do know that if the permit were denied based on all of the arguments that were presented by NWF, that Mr. Blevins' concerns would be fully addressed. And so the remedy that has been requested by NWF is appropriate because it redresses the errors that were alleged, and it provides a remedy that will also address Mr. Blevins' concerns. I'll note that TCEQ has not challenged the standing of NWF. I think GBRA is now challenging standing for NWF, claiming it's not an aggrieved party. The case they cited in support of this is the City of Dripping Springs case, which is not an environmental case. It's not an APA case. It doesn't apply here. And
That's a declaratory judgment case, right?
That's right, Your Honor. It's a declaratory judgment case, and within that opinion, the court was careful to distinguish the fact that it's a declaratory judgment case and not an environmental law case. And so it doesn't apply here. Again, under Hooks, we have also shown that we have met all of those same factors to show that they're standing here. NWF was fully a participant, not only in the negotiations that led to the resolution of some issues, but it fully participated as an adverse party in the SOA process and in the TCEQ proceeding.
Thank you, Ms. Perales.
Thank you.
Appellants.
Thank you.
Before you
Do
get
my-
going,
do my
let
best
me,
to
let
speak
me
into the
ask
mic.
you a standing question real
Okay.
quick. Assuming, just for the sake of argument, that y'all are correct on standing, why isn't this a case that would require a remand? Because there's been no affirmative negation of jurisdiction in their pleadings or evidence.
So the TCEQ is not challenging standing here. We're
Got the
challenging.
wrong person up here for that question, don't I? Okay.
Would you like to address the court on this issue?
Okay with y'all?
Sure.
Yeah, we've got a
Okay.
couple of standing questions.
It's a new court. We have no established rule.
May it please the court, could you ask your question again, Your Honor?
Yes, so if you're correct on standing, why isn't this a case that's a remand versus a rendition for lack of jurisdiction for the opportunity to replead and perhaps put on more evidence because there's been no affirmative negation of jurisdiction in the pleadings? Do you agree with that or disagree with that?
So the standing argument here is really whether the NWF has made the requisite showing under 2001-171 to get into court from its appeal of the administrative order, and that requires that it be both aggrieved by the final order and have exhausted. And where GBRA contends NWF didn't fully satisfy that is this aggrieved portion, and that I think I discussed with Justice Ferris earlier, the idea that this injury that NWF alleges must actually be redressable, and that's where GBRA contends that they have not shown that. But even if standing isn't quite the right couching terms, the case that I would direct you to is actually Dyer, the Texas Supreme Court from 2022, that said that, it was footnote 36, that talked about how in that case TCQ actually did brief standing, and it's a concept of 2001-171, and the court said, really what we're talking about is the ability of this party to get the relief that they seek, and that's 2001-174. So that's how it was resolved in Dyer, and that would make sense here as well. But it is intermingled, and it's similar questions with similar sets of facts. Does that answer your question?
No, I think so. Thank you.
Are there other questions for me? Thank you, Your Honors.
Right. I'd like to start by talking briefly about TCEQ's position that the site-specific standards, about whether the site-specific standards should still sometimes come into play. This is not a litigation position. The agency has always interpreted its directive from the legislature to be to apply the environmental flow standards instead of the pre-existing site-specific standards. And you can see that in the rulemaking for the Guadalupe River e-flow standards. GBRA actually asked this question. Are there some situations where we would still apply the 11.152 analysis in a new application for new water? And TCEQ responded and said no, quoted the statute and said, it is clear that the bill meant for the commission to place any environmental flow standards in a permit for new water instead of using other statutes and site-specific data. So National Wildlife Federation participated in that rulemaking and submitted its own comments and saw TCEQ's responses. That would have been the moment to challenge that interpretation of the statute. But that is TCEQ's understanding of the legislature's directive.
Well, but let's take that a little farther, though. Isn't the question, you're not challenging what the TCEQ says the rule might be, you're challenging what the rule ultimately is. If you're going to challenge the promulgation of a rule at that time, are you saying the rule makes it clear what the interpretation of this statute is?
The preamble of the rule for the e-flow standards made clear TCEQ's position is the e-flow standards replace the site-specific investigation under 11.152.
Always. And
Always, except for the I guess the potential for a strange situation that we're not in this case.
Right.
So I
but
couldn't speak to
effectively
that.
always.
But
yes.
practically always. That is TCEQ's position. We heard National Wildlife Federation's counsel say that she could not envision a situation where both where the 11.152 assessment wouldn't also be applied. So that interpretation that the commission should always conduct them both, an e-flows analysis and a site-specific habitat assessment, leaves us with this question of why instead of? Why would the legislature use the phrase instead of, which certainly implies replacement? It's a clue to the legislature's intention. And then, I want to zoom out a little bit and talk about plain language construction. So Texas Supreme Court has said recently that we have to discern.
You don't need to convince us on plain language.
Okay.
I don't
Well,
know, maybe she does, because apparently there's always context.
There's always context. There's always context, and we're aiming for the text fair meaning. So we are not looking at the individual words within the statute, but what 11.152 is aiming to accomplish as a whole. So we have to zoom out a bit from what 11.52 says. And that's where I would draw your attention to the heading under which the direction to apply 152 under 11.147 describes exactly what this review is within. It's effects of permit on bays and estuaries and in-stream uses. There is not another context aside from in-stream uses that 11.152 was designed to be applied to. There's another clue in the language of 152 in that it has a threshold requirement of 5,000 acre feet. And any diversion structure of any size, whether it's going to divert 1,000 or 5,000 or 3,000, would presumably have some impact on the land. But the legislature is not concerned in Chapter 11 on the impacts aside from those that mean diverting enough water to impact the habitat on the stream. So that's another clue about what 11.152 is meant to do.
Because 11.134B3, again, you have the and, but also right after the and, if applicable.
If applicable, right.
So what in the world? What does that mean?
Well, that's for you to decide.
Thanks.
It hasn't been
Right
construed.
That's a great
It
answer.
hasn't been construed by a court yet. I have just a little more time. I want to address the location requirements. The statute says only that the application should state the location and describe the proposed facilities. And GBRA's application does this. The map that you have in front of you shows 2 stars. Those are the points by longitude and latitude where the diversion reach will occur. And that was enough for TCQ to assess the effects of this permit because the e-flow standards account for every reach of the basin. And so there are actually permit conditions for diversions that would happen above. There's a gauge on the Guadalupe River in between those stars. And there are different permit conditions for diversions that would happen above that gauge and below that gauge. So the TCQ had enough information to assess the impacts of this permit on wildlife habitat and other in-stream uses, and that is why the diversion reach did not need to be more specific than that in this situation. And then I'm over time. I have one more.
Just briefly.
Brief point. Just because GBRA has this permit does not mean it is guaranteed to be able to withdraw the water that this permit allows. It can only take water from the stream if there is enough in the water course after e-flows are accounted for and after other water rights holders are accounted for. So the protection it is not just once you get this water permit, you can always take 75,000 acre feet of water. It will fully depend on the conditions of the river and the season.
Great.
Thank you.
Thank you very much. Thank you, counsel. Case is submitted. We'll take another brief recess before hearing the last case.
All rise.
seated, please.
Last case on docket this afternoon is City of Dallas versus Attorney General of Texas, Mr. Palmer.
Good afternoon. May it please the court, Nicholas Palmer for the City of Dallas. The Public Information Act's litigation exception serves to preserve the equal footing between governmental bodies and the individuals who may sue them by accepting from required public disclosure all information related to pending or reasonably anticipated litigation. In this appeal from cross motions for summary judgment, this court should reverse and render judgment for the City of Dallas because the city conclusively established that it reasonably anticipates litigation from Daryl Baker, the complainant in the proceedings before HUD. Alternatively, and at a minimum, the court should reverse and vacate the trial court's award of attorney's fees because on this record, the court had no discretion to award any attorney's fees whatsoever under the applicable fee provision. This afternoon, I intend to confine my remarks to two primary points, unless the court has any other questions about some of the ancillary matters in the briefing. Those points include the evidence in the record that establishes the reasonableness of the city's anticipation of litigation with Baker, and then finally, why it was an abuse of discretion for the trial court to award the Morning News.
So I do have one question that might go a little bit outside of that. There's the question of whether there was a waiver by failing to tell the AG, but then there's also the question of when you grant a summary judgment motion, it's got to be on the pleadings, right? So what in the pleadings talks about Baker?
Well, in the pleadings, the city stated that it was relying and incorporated its response to, or its original 10-day letter and its subsequent 15-day letter to the Attorney General.
But the letter also doesn't specifically mention Baker, right?
It does not mention him by name, although it does allude to him. I would direct your honor to page 160 of the record. And yes, although the city acknowledges that the record primarily talked about the pending and ongoing investigation with HUD and the circumstances surrounding that, it concluded by recognizing that the information, quote, has not been obtained by the opposing party to the litigation, end quote. And because in the letter, the city had acknowledged that HUD already had the information, in fact, that's the only reason the requester was seeking the information is because it was turned over to HUD, that representation could have only applied to one individual, and that would have been the complainant, Baker.
So why wouldn't, oh, sorry.
Go ahead.
So why wouldn't you amend the pleading to mention Baker?
Frankly, Your Honor, because the city did not feel that it needed to do so. The city felt that it adequately mentioned Baker, or that it adequately raised both pending litigation and the reasonable anticipation of litigation before HUD in its pleading such that it didn't need to say more, given that the letter was fully incorporated.
How does this work? You give all these documents to HUD, and then they don't get to Mr. Baker's attorney because?
Mr. Baker only has, under 42 U.S.C. 3612, only has entitlement to any of the information that HUD collects after HUD completes its investigation.
But there's not a prohibition on HUD giving it to them before that, right? They don't have a statutory entitlement until the investigation's over, right?
I would say that's a fair reading of the statute, Your Honor. However, there has been no evidence offered by either party that HUD has shared anything with Baker.
Do they have any kind of litigation or anticipated litigation objection under the Freedom of Information Act?
HUD has not raised any type of objection to the disclosure of the materials.
He hasn't requested them from HUD.
But there is no evidence that he has requested, or that Ms. Ambrose, the requestor, has requested them from HUD. She's only requested them directly from the city to the city's knowledge. Justice Ferris, I'd like to follow up on your waiver argument by stating that there's a statutory text problem with the Morning News waiver argument as well. And that is because the Morning News relies on Section 552.326 of the Public Information Act to say that the city waived the anticipation of litigation with Baker. However, that provision reads in full that the only exceptions to required disclosure that a governmental body may raise are those exceptions that a governmental body properly raises before the Attorney General. And
But isn't the question like whether this was properly raised? I mean, everybody's asking people to read a lot into it that's not on the text. I mean, when we go to the Attorney General for a decision, isn't the Attorney General only able to consider what's before him? And if it's not spelled out, how far does the Attorney General have to go in, trying to figure out the backstory when it's not actually in the text of the letter?
the Attorney General is confined to the information that is submitted to him. But importantly, under Cornyn versus City of Garland, which is cited many of times throughout the party's briefing, the administrative proceedings before the Attorney General are not a formal adjudication to which rigid appellate preservation matters apply. It is simply
Sure, it's
an
not an
administrative
adversarial,
request
right.
for an advisory proceeding. And therefore, when if the government wants to challenge his decision on that and chooses to sue, that's the first time there's an adversarial proceeding where the dispute is going to be decided by proof. Because mind you, Your Honor, that many of the times with the Attorney General, he is only making his determination based on representations, not on evidence. He reviews the material at issue, but governmental bodies don't have to substantiate all of the facts they use in their argument before the Attorney General with evidence like they have to do in a court of law. And that's why under Cornyn versus Garland, so long as the appropriate statutory exception was raised before the Attorney General, the city is permitted to augment and refine its arguments in a court of law. If it's within
In its pleading, but it's got to be in the pleadings, right?
It's got to be supported by the pleading and the evidence, Your Honor.
Can I ask you just a totally different subject, quickly, just on procedure? They raised the issue of the no evidence motion for summary judgment. What exactly would Dallas Morning News have had to put in their no evidence summary judgment motion for it to be valid in the city's view?
I think for the Dallas Morning News to have prevailed on no evidence motion for summary judgment, they would have had to say that the city has no evidence that it had a discovery interest in the information at issue because it has either violated the selective disclosure rule, or it has been given to all parties to the litigation, or the finite time frame for which the discovery interest lasts has lapsed. It would have to raise some element that indicates that of the city's case in chief for which it could not produce any evidence. And the Morning News did not do so here. The Morning News, in a single sentence, just also said, oh, and we're bringing forward a no evidence motion for summary judgment without indicating any of the elements for which it felt the city could not prove its
So it's
case.
just that one sentence, and that's all there is?
It's just that one sentence, that's all there is. There's in fact not even a ground listed in their grounds for summary judgment on no evidence grounds.
But I mean, isn't procedurally the duty of the respondent to summary judgment then to either object or file special exceptions to the summary judgment motion?
I think, Your Honor, we adequately addressed it in our response to the summary judgment motion because our view of their summary judgment motion, although it was labeled traditional and no evidence, was that it was, for all intents and purposes, traditional. And, you know, we addressed the inadequacy of their no evidence point in the substance of our response to their motion for summary judgment. I do want to take a few moments in my last 5 minutes here and talk about the fee provision that is at issue in this case, because it's a unique fee provision that very few appellate courts have. and no appellate court has substantively opined upon. And the fee provision at issue is section 552.323. Importantly, this is not a simple prevailing party fee provision. Yes, to obtain fees under 552.323, a party must substantially prevail. However, even after a party substantially prevails, the court may not assess costs and fees against a government body if the court finds that the government body acted in reasonable reliance on the published opinion of an appellate court and or a written decision of the Attorney General. And so, for all of the reasons outlined in the city's briefing, I think at the threshold, the Morning News was not entitled to be a prevailing party because the trial court should have rendered judgment for the city under the litigation exception. But even if the court were not to agree on that front and were to affirm on the findings of the litigation exception, what 552.323 essentially does is imposes a good faith prohibition. The government can challenge the Attorney General's findings only in good faith. And so long as those arguments are reasonably supported by appellate court decisions and by written decisions of the Attorney General, fees are not in play.
Got it. So, what is the materials that they asked? They asked for 23 categories, most of which looks like exactly what Mr. Baker would ask for in his lawsuit, or which was available under Freedom of Information Act. I mean, the list of federal funds the city received from HUD, there's nothing confidential about that, right? Or list of redevelopment areas and the respective census tracts and zip codes. So is there, I mean, we know what this ball game is about. What plaintiff's attorneys are looking in documents is not what the facts are. They're looking for some admission by somebody in your office that we messed up maybe, or we've got a problem here, because that's what trials are all about. They're not about all this statistic stuff, which you could get otherwise. So why shouldn't you point that out to us or to the trial court if what this is really about is, you know, those little quote-unquote smoking guns that are often not smoking guns. They're perfectly, but a jury's going to look at it that way. So why not, rather than just saying this whole thing's, you know, subject to litigation, why don't we respond to the Attorney General with something manageable that says, cut out this page and this page and this page because they're just opinions of our attorneys?
Well, and Your Honor, I have
In
two.
hindsight, why shouldn't that be the rule?
Yes, in hindsight, I have two responses to that. The information at issue in this case is actually rather voluminous.
Oh, I'm sure it is.
And so, given the 15-day timeline to turn information over to the Attorney General, the city could not definitively go through all of the documents to try to catch 1 or 2 pages of a smoking gun. But also, Mr. Chief Justice, I think your question highlights kind of the quandary that the city finds itself in here. And that is that some of this information, you know, classically would be the type of public information. But once there is a reasonable anticipation of litigation, litigation exception serves to make sure that either opposing party to the litigation has to obtain that information through the discovery process, be it HUD or be it Baker.
And that way you have more time to look through it and raise your overbroad, blah, blah, blah objections.
Exactly, Your Honor. But what the Public Information Act also does is it has a rule against selective disclosure. And what that means is the city cannot voluntarily give the information to anybody, or it has to give it to everybody. And so when the city received Ms. Ambrose's request, if we were to give it to Ambrose, we would forfeit our discovery interest with respect to Baker, because we could no longer invoke it under the Public Information Act's selective disclosure rule. And so the city is really trying to preserve its discovery interest as to Baker, which is the primary reason it has objected to the records in this proceeding. And I see that I am low on time and at risk of running over. I've got some time in rebuttal.
We'll
that
give
I
you,
will
we'll
bring
give you
up
back
some-
26 seconds on rebuttal.
Thank you, Your Honor.
For the morning news, I guess. Attorney General didn't show up.
Yes, Your Honor. May it please the court, for the intervener, Dallas Morning News.
Right.
Your Honor, the trial court's judgment should be affirmed for 4 separate reasons. The first reason is that the plain language of Section 552.326 of the Government Code requires it, because they are relying upon an exception that they did not properly raise before.
They did
the
mention
Attorney
it.
General. They relied on 103, but they did not properly raise the exception
Because they didn't do what?
because they did not raise as a ground for the application of the exception the reasonable anticipation of litigation with Darrell Baker.
So let me make sure I got this. Your position is the Attorney General's office, nobody has to have a brain over there. They just have to look at the letter and see if the words 103 and Baker were in it. And the fact that you've got letters from HUD and that's part of the information that says Baker versus City of Dallas, nobody has to think about, gosh, I wonder if that's really the party that they're worried about.
No, Your Honor, I think what Section 326 requires is that the governmental body tell the Attorney General, and ultimately in litigation, if it goes that far, how it is planning to argue the applicability of the exception. So under Section 103, for example, the governmental body can invoke Section 103 either because there's pending litigation or because there's reasonably anticipated litigation. Now, they're not the same thing. And if the word properly is going to mean anything in Section 326, it at least should impose that much of a burden on the governmental body to...
I might agree with you in a lot of cases, but in HUD cases and EEOC cases, everybody knows what happens. You send an administrative complaint in, the administrative agency brings it in your name for you, or sends you a right to sue letter, and you bring it for yourself. There's only those 2 possibilities. We're not worried about other people in Dallas. There's just, it's either going to be HUD or Baker, and that was plain on the face, if not the letter, of the attachments.
Well, Your Honor, I think the letter was pretty plain that they were talking about pending litigation. They referred to pending litigation that is still ongoing, active litigation, issues raised relevant to the lawsuit, and allegations raised against the city. Now, the reason it matters in this case, Your Honor, is of course because they disclosed it to HUD. So if all we're talking about is pending litigation with HUD, as I think we should, then 103 does not apply because it's been disclosed. I would distinguish an EEOC case, Your Honor, from this case, and that gets into whether they in fact establish the presence of reasonably anticipated litigation with Baker. The only summary judgment evidence we have is the complaint itself. Now, under Section 103, the applicable date for determining if the exception applies is the date the requestor made the request, which in this case was January 3rd, 2023. Now, by that time, the complaint was a year old. We have no evidence put forward by the city as to whether Baker made any threat, whether he said anything, whether there was any reason to believe that if HUD did not take it all the way through, he was going to do it himself. And it was their burden to establish the applicability of that exception, and we don't have anything. The other distinction, I think, Your Honor, between this case and for the court's example of an EEOC case, Baker's complaint is not the kind of complaint somebody is likely to bring on their own. He's not claiming damages for himself. He's claiming that the city has disproportionately approved low-income housing tax credit projects in neighborhoods that are already predominantly low-income. And so it's really more of a policy-type argument. He's brought it to the attention of HUD, which has the authority to take it through. But this is not the kind of complaint like an EEOC claim where it is reasonable to anticipate just from the 4 corners of his complaint, because that's all we've got, that he would ever bring litigation himself.
Well, he did, I mean, the letter from his attorney says, it's in my neighborhood and it's affecting my house.
Correct. Correct. It does say that, but it's not a claim for monetary damages. And I think in the city's response to HUD, which is in the summary judgment record, they said their response to HUD in April of 2022, so a full 8 months before Ambrose made her public information act request. They argued quite forcefully and perhaps persuasively that he lacked standing for that very reason. He has no damages. It's a claim that, as I said, it's really more of a policy claim that you're not properly distributing low-income housing projects throughout the city, as Mr. Baker presumably believes you should.
I'm sorry, I'm a little hard of hearing. So is Baker's claim gone now?
No, Baker could still bring his claim because
He's got to get the right to sue letter from the HUD or whatever?
yes, because it's because limitations is told while HUD is investigating. He normally would have a 2-year statute, but it's told while the HUD investigation is going on. So again, Your Honor, back to I think those are the two key flaws in the city's position. The exception, the way in which they are now arguing it and the way in which they argued it in the trial court is not what they properly raised before the Attorney General. And moreover, to your question to the city's counsel, Justice Ferris, their pleadings didn't say anything about anticipated litigation with Mr. Baker. They just pled it's exempt under 103. And importantly, their disclosures didn't either. Their disclosures just referred back to the Attorney General's letter. And those disclosures were never amended. They were never supplemented. And in the litigation, we're entitled to rely on that. And so nothing until they finally filed their own cross motion for summary judgment suggested that the possibility of reasonably anticipated litigation with Darrell Baker, not with HUD, but with Darrell Baker was going to be the basis for the claim of 103 exception. I think, Your Honor, the other issue I'd say on the city's failure to establish the reasonable anticipation of litigation with Baker is to compare our record, which is, again, only the complaint itself, to the kind of record that we see in some cases in which courts did find the reasonable anticipation of litigation. And I think two of the ones that illustrate it pretty well are the University of Texas Law School case and BWB against Eanes Independent School District. And in those cases, the governmental body had put in evidence of, for example, in the Eanes Independent School District, the requestor was an attorney. He was the parent of a child and obviously more likely to be motivated to litigate than in a situation like Mr. Baker. He had told the officials at the school district, don't talk to my child, and if you do, I'm going to sue you. And so you really had some concrete evidence on which initially the school district, secondarily the Attorney General, and thirdly the court could find a reasonable anticipation of litigation. In the UT Law School case, of course, the guy said, I'm submitting this request because I'm looking for potential plaintiffs to sue you, which was a pretty strong argument that there was a reasonable anticipation of litigation. We don't have any of that here. All we have is the record. We don't know if he's ever threatened. Is he litigious? Does he have the means to pursue a lawsuit? And importantly, as I said, the nature of the claim is such that it seems to me it doesn't necessarily follow that there would be a reasonable anticipation of litigation.
Is submitting to the Attorney General mandatory here?
Yes. Yes, with a caveat. If the governmental body fails to seek an Attorney General ruling in a timely manner, then the information is presumed to be public. Now, that presumption is subject to quite a few exceptions. But yes, you start with the premise that the governmental body must timely seek an Attorney General ruling, or there is a presumption of openness. And of course, the entire statute has a presumption of openness. Under 552.001, it tells us that the entire statute must be construed in favor of the granting of information.
Except for these 100 exceptions.
Well, those are exceptions, the legislature has given us.
Absolutely.
And there are quite a few of them, Your Honor. Yes, there are. Yes, there are. But what I would suggest to the court is, the relevance of that, in our view, is when we are construing 552.326 and its use of the term properly, I think we have to do so in the context of a statutory presumption in favor of openness. And really, this isn't asking too much of the governmental body. When the governmental body gets in a Public Information Act request and is going to send it to the Attorney General, they know what the information is, they know what the grounds are. The requestor doesn't. As counsel for the city pointed out, the Attorney General will generally accept as true factual representations the governmental body makes. So to ask the governmental body to at least tell me what you're relying on, which they didn't do here, I think is not burdensome. And the interpretation we're suggesting of 326, I think, gives meaning to the presumption in 001 that everything be interpreted in such a way as to presume public availability.
Mr. Williams, what is like the minimum that you think they should have done to not waive it in the Morning News's view?
I think, Your Honor, what I think is, with respect to exceptions for which there is more than one way the exception might be applicable, to give any meaning at all to the word properly in 326, the governmental body must at least tell us which method of getting to that claimed exception it is on which they are relying. So, bringing it back to our case under 103, 103 can be applicable one of two ways. Either there's pending litigation or there's reasonably anticipated litigation. At least if 326 is going to mean anything, the governmental body should tell us which one, and preferably with more detail. Now, pending litigation is easy because you can see it and you know it's there, and the reasonable anticipation of litigation typically requires the governmental body to give some additional background and context. But at least tell us which one you're relying on and generally what it is. So number one, the Attorney General can evaluate it. And number two, if it does go to litigation, the litigants and the courts can evaluate it.
So what is the consequence if it's waived? If they were required to give more information to the Attorney General and they didn't do it, what then?
Well, then the trial court's ruling was proper because
But is that enough for attorney's fees here?
Yes, let me address then the attorney's fees
Okay.
provision, Your Honor. So, because the Morning News was successful in obtaining a writ of mandamus under section 552.323A, attorney's fees are mandatory unless the city obtains a finding that it acted in reasonable reliance on an appropriate authority. Now, the city did not obtain such a finding, and the attorney's fees award is reviewed on an abuse of discretion basis. So all the city put in, well, number one, we don't actually have any evidence that they in fact relied on it. The city filed a pleading in which it just referred to authority that it had cited in its summary judgment papers. But the presumption is, I would actually differ with counsel for the city on that, because the presumption is actually that fees shall be awarded unless the trial court makes the finding that there was an appropriate reliance on other authority. This trial court didn't make that finding. And therefore, especially on an abuse of discretion basis, we have to assume the trial court felt that perhaps the authorities were not on point, for example. The analysis of the reasonable anticipation of litigation issue generally becomes a pretty fact-specific and case-by-case analysis. So for all we know from the record we have, the trial court did not find those authorities that were cited in their unsworn pleading on point. And at least with our record and an abuse of discretion standard as we have here, the trial court did not abuse its discretion in awarding the fees.
So what is the, so first refresh my recollection. Were you all, the newspaper a requester?
Yes, Your Honor.
Okay. And so this 323, the A appears to apply to actions under 321 or 3215, but B to 324. 324 is suit by a governmental body seeking to withhold. So do both of those apply, A and B, or just B? Or if both of them apply, does just B, because it looks like it's maybe more protective of governmental bodies than A? How do they work together?
It is more protective, Your Honor, and in our case, it is A that applies because the Morning News, as intervener, sought a writ of mandamus under section 552.321, and so that triggers A in the presumption that I've outlined. I don't know, Your Honor, that of an appellate opinion that has specifically focused on that issue. There are several out there in which interveners have been awarded attorney's fees in the same procedural context we have today, and courts of appeals have affirmed that. Thomas versus Cornyn was one of the earlier ones. Atkinson versus Paxton is a more recent case. Those cases had the same procedural posture we have here, where the governmental body sued the Attorney General and the requestor then intervened, and fees were awarded to the intervener. I think, Your Honor, B would only apply in the situation in which all you had was the governmental body and the Attorney General. And I do think the court is correct. B is a more favorable to the governmental body than A.
I see what you mean.
Your Honor, very briefly, I do want to mention another issue that Mr. Palmer touched on, and that's the provision in the Public Information Act at 552.007 that provides that if the governmental body voluntarily discloses information to someone, then it then becomes public for all. And it's our position that that's what happened here, and that's another reason the trial court's judgment should be affirmed.
But is it really voluntary when, HUD kind of suggests there may be consequences if you don't do it?
So I would say two things, Your Honor. Number one, 007 just says voluntary. It doesn't say sort of voluntary or voluntary because...
Voluntary-ish.
That's voluntary under duress.
But more importantly, if we are going to assume that threat of subpoena, to use their language in their briefing, is an exception, you don't have it here. The letter from HUD very clearly says we're asking you to do it voluntarily. Now, it is true, it goes on to say we have subpoena power, but that's just a statement of the law. It didn't say, if we don't get it by 5 o'clock Friday, we're coming. There's nothing like that. And what I think the way a governmental body can reconcile that and still be cooperative in a situation like this, which they understandably wish to be, is say, yes, we'll give you all this information that you're asking us to produce voluntarily, but we need a subpoena, and we just need it for the record. And we're not being difficult. The city attorney could say, I'll accept service. You can email it. You don't have to go out and hire a process server, do anything like that. And then there would be no issue that the production to HUD had been voluntary. It would be clear that it had been provided because compelled by law.
So they wouldn't have to fight it until you get a motion to compel or something like that?
Well, I guess, sure, if it were bad adversarial, certainly. But I think what I'm suggesting is the governmental body can protect its position under the Public Information Act without appearing to be uncooperative by saying, I'm going to need you to serve me with a subpoena so that I don't get in trouble.
So it's pursuant to a court order rather than...
That's right. And then when Sue Ambrose comes in and asks for it under the Public Information Act, I can say, well, we were obligated to give it pursuant to a lawful subpoena. Unless there are other questions for the court,
Anything
I'm
else?
out of time.
You're going to give us 30 seconds back, Mr. Williams?
Yes, Your Honor.
Thank you very much. Oh, good, sorry. Well, they have these wonderful nameplates, so I couldn't see you, I apologize.
May it please the court,
Yes.
once again, Nicholas Palmer for the City of Dallas. I want to make two brief points on the fee issue before wrapping up with the reasonableness of the city's anticipation of litigation. First, well, excuse me, I said the fee issue with respect to the waiver issue. First, I'd like to point out the city did, in its pleading, Justice Fair, specifically invoke the litigation exception 103, which by its express terms covers litigation and reasonable anticipation of litigation. And my friend on the other side wants the court to adopt this rigid appellate-like issue waiver mechanism when when a governmental body goes to the Attorney General asking, does this information fall within this exception? And I think the court should be hesitant to do so, particularly in light of cases like Cornyn versus City of Garland, which has governed this process since the 1990s, because throughout the state, many governmental bodies don't use attorneys to communicate with the Attorney General on these matters. It's lay people, civil servants who aren't versed in matters of appellate procedure and issue preservation who say, excuse me, Mr. Attorney General, I don't think we have to give this information because of this exception. And then if that saves taxpayer resources because
But here, just adding the guy's name would have saved all of these resources that got the case here today. I mean, isn't it better to require at least a little bit of detail on the front end so that the Attorney General has something to work with?
But the point, Your Honor, is I don't know that a layperson would know that they would need to say, other than the party I'm concerned about doesn't have the information, that party is Baker. I don't know, I think that's too finite for a layperson who might be going to the Attorney General to know they have to be that detailed. And I also think what should be instructive to the court is that although my friend Ms. Johnson with the Attorney General's office is here, the Attorney General in the trial court and in this court has declined to defend his administrative decision and is not asking the court to affirm on the basis of waiver. And surely, if there was any merit to the Morning News waiver argument, the Attorney General would jump on that bandwagon, because the Attorney General is not in the business of enjoying to see his administrative decisions overturned by the court. Because I didn't get an opportunity to talk about it in my principal remarks, I would like to briefly talk about the reasonableness of the city's anticipation of litigation with Baker. So Baker filed a complaint with HUD. That complaint has triggered an investigation which has been ongoing and they've requested the City of Dallas to produce voluminous documents, which the city has done, and on each time they have reminded the city that should we not do so, they have subpoena power. That is the verbiage they use in their letter. I think that is sufficient to show that the disclosure is not voluntary for purposes of the Public Information Act. The investigation is ongoing. Everybody here, and I'm sure Mr. Baker himself, wishes HUD would move along, but it keeps giving itself extensions. And so that investigation is ongoing. And why that's important is because when HUD finishes the investigation, it's going to do one of two things. It's either going to initiate quasi-judicial proceedings before HUD ALJ, and that ALJ has the authority to award damages and issue injunctive or declaratory relief, or it will dismiss Baker's complaint. And in either scenario, Baker can intervene in the HUD administrative proceedings, or if he doesn't fare well and get HUD to, pardon the phrase, like foot the bill by taking the case for him, he still can sue the city in federal court at that point, because the statute of limitations is told for the duration of HUD's administrative review process. And to wrap it up, I'd like to point out one other fact within the four corners of Mr. Baker's complaint that shows that the city's anticipation of litigation is reasonable, is the fact that Baker retained counsel. It's on his complaint, Daniel and Beshara, PC. And the University of Texas Law School case teaches us that it's not just the fact of retaining counsel, it's who that counsel is. And the city has significant experience with Daniel and Beshara, PC. They specialize in bringing housing discriminations complaints and have repeatedly sued the city. And I can give a couple of citations to the Federal Reporter where it has been Daniel Infrastructure versus PC versus the City of Dallas.
But, I mean, this goes beyond the record, right?
Well,
Before-
yes,
yeah.
that's beyond the record, but it's a matter of public record, published decision that the court can consider. But it all goes to show the reasonableness of the anticipation. And for these reasons, the city would request that the court reverse and render, or at a minimum, reverse and vacate the fee, or affirm and reverse and vacate the fee award.
Gotcha. Thank you very much. Marshal will adjourn the court.
All rise. 15 Court of Appeals now stands adjourned.